welcome ANO alum John Fisher and former ANO Special Global Counsel Philip Wood KC. Earlier this year, John and Philip's session, Law and Christianity, How the Romans Made the Modern World and What Changed, looked at how for over 1500 years, law and Christianity had kept civilization together. This talk will look at the creation of the common law in 1189 from Roman law and compare the latter to aspects of common law, of modern law. I will submit any questions that come through to John and Philip at the end of this session. And I will now hand over to John and Philip. Thank you very much.
Okay, Stella, thank you very much for inviting me to give this talk. When 250,000 people paid their final respects to Queen Elizabeth II in Westminster Hall last year, few would have known that they were walking on the ground where the common law was created in around 1189. This had been preceded by one of the great unrecognised turning points in the history of civilization, when in 1151, England rejected the reception or receiving back of Roman law. All this took place against the background of an English civil war, in the middle of which came probably the most influential lawyer ever to practice in England, Roger Vicarius. It was Vicarius who, more than anybody else, ensured that the common law was built on Roman law foundations. How did we get here? Generally speaking, the concepts of all the world's 320 jurisdictions are contained in Justinian's Digest. None are indigenous. The Digest was produced in 533 AD in Constantinople. It was culled from 1,500 books of juris opinions, 30 times the size of the Bible, covering over 1,000 years of Roman law. It was 1.5 times the size of the Bible, took only 3 years to put together, and was a copy and paste job. When it was produced, Justinian stated it contained the whole of Roman law and ordered all 1,500 books of juris opinions to be destroyed. After Justinian died in 565 AD, the Digest ceased to be used. It was too complicated for people to understand, as the collapse of civilization in the East was severe, although not as severe as in England. In any event, it was in Latin, and in the East they spoke Greek. The Digest was lost for over 500 years, until a copy was found at Amalfi in Italy in 1070. It is now in Florence. We are not sure how it got to Amalfi. Either it was left in Italy following Justinian's attempts to reconquer in the 6th century, or it was brought over from Constantinople by scholars fleeing from the advancing Muslim caliphates. The importance of the Digest was immediately recognized. It was glossed or notes inserted explaining the concepts by the law faculty of Bologna University. This was completed by 1100. The reception or receiving back of Roman law then swept through Europe. In 1129, a copy of the glossed Digest came to England, and the reception started here. So much so that in a major court case in 1143 concerning land, the great civil lawyer Roger Vicarius, aged 23, was brought over from Bologna University as part of the church's legal team. They won the dispute against King Stephen's brother. Now civil law was becoming popular, and the reception was gathering pace. By 1149, Roger Vicarius was lecturing at Oxford University on the Digest. Vicarius's lecture notes and large sections of the Digest were produced in his Liber Pauperum, which in 9 volumes was the only textbook on the Digest in England at the time. Almost a full copy of Vicarius's Liber Pauperum is now in Worcester Cathedral Library. So widespread was the acceptance of the reception in legal circles by 1151 that a decision had to be made on whether or not to officially recognise it, as most of Europe had done. We have a summary of the debate. The telling statement decisively rejecting the reception was that it was very unfit for the English constitution or genius. Consequently, King Stephen passed an edict silencing Vicarius and banning anybody from reading his books or having them in their possession. They had to be destroyed. Although not recognised then or now, 1151 was a turning point in the history of civilization. The formal rejection of Roman law in England led to the creation of the common law. What has just been stated must be set against the political events at the time. The death of Henry I in 1135 left no clear line of succession. There were 2 Norman claimants, William the Conqueror's grandchildren, Stephen and Matilda. Matilda was married to a Plantagenet. Stephen and Matilda fought each other from 1138 to 1153 for 15 years. The civil war was settled on the basis that Stephen would continue to reign until his death. whereupon Matilda's son Henry would become king. And Henry becoming king in 1154, he did not overturn the rejection of Justinian's Digest, but he did reverse the silency of Roger Vicarius, and civil law soon again became a favourite subject at Oxford University. Roger Vicarius, the one man who above all others had caused this crisis in the legal profession in 1151, continued to be held in high regard despite the reception having been rejected. The Attorney General to King Stephen and Henry II stated, "P. Vicarius was a great honour to the age he lived in, whether one looks at his religion or learning. He had a very long active life in England, dying in 1200 when he was 80. Fragments of Vicarius's Liber Pauperum, copied by students trying to learn the law, from the 1190s can be found in the Bodleian Library and in several of the college libraries such as Balliol at Oxford. In the 13th century, Roman law was taught at Cambridge. These are two of the world's most prestigious universities today. However, until the 19th century, they're even more important than this. For hundreds of years, they've been right at the heart of government. Why would these two universities teach Roman law, if it was not relevant to English law? If English law had always been customary, they would surely teach this. From about 1175 to 1979, when the court was abolished, the Chancellor of Oxford University's court had jurisdiction to hear any civil or criminal claim brought by anyone in connection with the university. Oscar Wilde was a defendant in civil claims before this court twice. Until 1854, civil law claims were decided in accordance with the Roman law, for an Act of Parliament abolished this and said the court had to apply the common law. Thus, even after we had rejected the reception and English law was said to be based on custom, the Chancellor's Court until 1854 decided all civil law cases in accordance with Roman law. We are the only country to have rejected a ready-made, sophisticated legal code in preference for what? The freedom on the face of it to build an alternative legal code from scratch. This would be almost impossible. It had taken the Romans over 1,000 years to devise the concepts in Justinian's Digest, and lawyers instinctively reached for precedents rather than doing things from scratch. So did we actually reject Roman law? It was stated to be contrary to the English genius to accept a foreign structure, such as Roman law, contained in Justinian's Digest. The English genius has always been to take old institutions and learn to work with the grain, to make them adapt, stretch, shift, and be flexible to change. Change within the settled traditions of the country. Particularly after a 50-year civil war, preceded by an utterly brutal Norman conquest on an Anglo-Saxon state, change had to be like pouring new wine into old bottles without breaking the bottles and at the same time improving the vintage. Until today, the bottle has only broken on 2 occasions, first during the English Civil War of the 17th century and then with the American Revolution. In both cases, if the English genius had been applied, these catastrophes could have easily been avoided. Constitutional settlements of 1660 or 1689 could have been applied in the 1640s. The self-governing Dominion status could have been given to the American colonies, with defense of North America shared with America and the Royal Navy, based in Canada and the Caribbean. Thus, the English genius is a solution to keep society together whilst effecting change. Contrast recent divisive referenda, where the English genius was ignored. As we shall see, we not only adopted Roman law without bursting the bottle, but we improved the vintage. The English genius has been astonishingly successful, because most people think the difference between a common law and civil law is that the former is based on English customary law, whereas the latter is based on Roman law. The former, I suggest, is simply wrong. Westminster Hall, part of the Palace of Westminster, right next to the House of Commons, was built in 1097 by William II, William the Conqueror's son. It is here that the common law was created by Henry II. When Henry II came to the throne in 1154, the English court system was a terrible muddle. Normal courts had been superimposed on Anglo-Saxon courts. All had overlapping jurisdictions, and defendants procrastinated with jurisdictional points. Of the plethora of courts, the most important was the King's Council, or Curia Regis, which travelled around with the king. Its jurisdiction was almost unlimited, with executive, legislative, and judicial functions. Being composed of a large body of lawyers, peers, and clerics, it was simply too unwieldy to deal with the nation's day-to-day business. Henry II reformed the court system, not only by organising 6 circuits of judges to hear cases around the country, but more importantly, by establishing permanent courts in Westminster Hall. he decreed that 5 judges should permanently sit in London for the benefit of litigants. The other Saxon and Norman courts were just allowed to wither away. Common law is legal jargon for judge-made law, or law based on previous cases. It was in these courts in Westminster Hall, known as the Bench, that the judges decided cases that became the common law. This is why Henry II is considered to be the father of the common law. The court of the king before the king, or King's Bench, heard cases involving the king and his subjects. The court of common pleas, or common bench, heard actions between subject and subject. So why do these judges not just apply the law in Justinian's Digest like every other country had done? The problem was that Roman law can never recognize the royal prerogative, because the Romans had overthrown their kings in 509 BC when they founded the Republic. Thus, it was contrary to our constitution. This is not just some academic problem, it is still relevant today. When Henry VIII instituted the English Reformation in the 16th century, because his wife Catherine of Aragon could not give him a son, the power to appoint notary publics was transferred from the Catholic Church to Henry VIII. A notary's authority until recently came from the royal prerogative, which civil law does not recognise. To get over this, the Hague Convention was signed in 1961, which stated that if an English notarial act had an apostille attached to it issued by the Foreign Office, then this would be accepted in civil law countries. During the recent COVID crisis, the Foreign Office stated that they had to shut down their apostille service because it was completely impossible to provide a safe space. They wrote a letter to the major civil law countries asking them to accept documents without an apostille. They did not get one reply. 2,500 years of history were not going to be changed by a mere pandemic. With cardboard boxes of documents requiring an apostille piling up at the Foreign Office, they discovered it was possible after all for a certificate to be attached to a piece of paper safely, and they reopened the apostille service. Thus, the royal prerogative is still very much part of our constitution today, and as in the 12th century, so today, Roman or civil law cannot accept it. Henry II was a Plantagenet, successor to the Normans, who themselves were successors to the Vikings. When it came to a bloodline ruthlessly fixated and wholly onto power, there was none more focused than this. Henry also came to power after a vicious civil war. There was no way he was going to give up the royal prerogative. Similar reasons may have been why King Stephen passed his edict banning Roger Vicarius, and we rejected civil law. The royal prerogative in England gave the monarch huge power, not only to appoint and dismiss judges, which we are concerned about here, but for example, to declare war. Roman law would further render impossible the whole purpose of the common law, i.e. that law made by judges is binding. In fact, common law is as much law as an act of parliament. The royal prerogative to declare war has now devolved from the sovereign to the prime minister. Churchill confirmed on the telephone with Roosevelt what he had heard on the Sunday BBC 9 o'clock news on 9th December 1941, that Japan had attacked Pearl Harbor. At 1 o'clock on Monday morning, the 8th of December, he exercised the royal prerogative and declared war on Japan without consulting Parliament or anybody. Going back to the Chancellor of Oxford University's court, if prior to 1854, a notary sued an Oxford student for an unpaid fee, the student could avoid payment by alleging the notary was acting under the royal prerogative. Further, prior to this date, an appeal from this court to the Court of Appeal, or the High Court if judicial review was applied, would have to be decided in accordance with Roman law. The Curia Regis was an ancient institution. It was certainly around in Anglo-Saxon times. Indeed, the Romans had had a pretty similar institution. Applying the English genius, Henry II hived off the judicial functions of the Curia Regis. He still kept the king's name, but called it the King's Bench. The judicial and legislative functions were still housed together in the Palace of Westminster, as they were until recently when the Judicial Committee of the House of Lords was abolished as the highest court of justice and replaced by a Supreme Court, which sits in another building. As Roger Vicarius had demonstrated, civil law was certainly only popular in the legal profession, but what other alternative was there? To this day, no country in the world has found a practical alternative to Justinian's Digest, except with regards to land law, which is based on feudal customary law. We have to have a comprehensive and coherent legal code system. Billions of contracts in the world every day are voluntarily entered into, generally based on the concepts in Justinian's Digest. Nothing else would work. The contract textbook has chapters covering, for example, formation, performance, terms, transfer of property, transfer of risk, mercantile quality, design liability, tracing of legal title, termination, etc. Why? Because bear in mind the huge number of contracts entered into every day, which has been the case throughout history, particularly as far as we are concerned in Roman times. We had to have a legal code which covers disputes in all these areas. Fortunately for us, the Roman jurists left us with a detailed contractual code. The English genius was applied. Have a common law system but cover up its Roman origins. The judging cautiously expressly introduces a concept from Roman law. This may be overturned on appeal, or Parliament will pass legislation confirming the judge's original decision. For those who think that English contract law comes from custom, law merchant, or Anglo-Saxon legal codes, where is the required detailed evidence for this? It does not exist. In any event, the law merchant was based on Roman law. Within the last 100 years or so, China, Japan, and Thailand, for example, have had to import the German legal code because it did not have the indigenous equivalent. The German legal code was user-friendly. The common law containing hundreds of thousands of cases is not. What I have said about the common law covering out Roman law concepts is corroborated in writing. 1189 Glanville, the first textbook of English law, was produced, hence the date of this talk. This was followed in the 1220s by Bracton. The preface and introductory chapters of Glanville are taken from the preface to Justinian's Institutes, and all through the book are traces of the influences of Roman concepts, more or less adapted to suit a developing English law. Justinian's Institutes is a summary of the digest for students. In my view, it is much more likely that Glanville is based both on the digest, with the Institute's used as name memoir. The digest is so much easier to understand. Further, Glanville was a student of Roger Vicarius at Oxford. In these circumstances, it is surely inconceivable that Glanville will not use Vicarius's lecture notes contained in his Liber Pauperum. As Frederick Maitland, the greatest English legal historian, commented on Glanville, there are a few sentences in it which can be traced to any Roman book, and yet in a sense the whole book is Roman. The use of Roman legal concepts is even more pronounced in Bracton's 13th century textbook. The same happened in 1933 in Donoghue and Stevenson. The Scottish judge Lord Macmillan applied pure Roman law concepts, which were familiar to him as a Scottish lawyer. We have a copy of his original judgment. Lord Atkin asked him to keep all the concepts but delete all the references to their sources. He took the second commandment, you shall love your neighbour, and changed it to you shall have a duty of care towards your neighbour. Then applied all the concepts which Lord Macmillan has set out in his judgment, and stated that they had always been part of the common law. So was the tort of product liability born. The law of treaties, which resulted from the Vienna Convention, is also based on Roman law, and was ratified by the United Kingdom in 1971. So we have no problem with Roman law. The problem concerned the royal prerogative. To summarise, sovereign's one goal was to hang on to power. Particularly after a 15-year civil war, the king was not going to give up the royal prerogative, which would be the case if England adopted Justinian's Digest, as the rest of Europe had done with the reception. Because of what happened in 509 BC, Roman law could not accept the royal prerogative. On the other hand, there was no other legal code. So the solution was to use the legal concepts in the Digest, but to disavow their origins. It is the genius of Glanville and Bracton to use the legal concepts in the Digest, but make them seem that they'd always been the basis of English law. The decision to do this came from the top of English politics. Glanville was Chief Justice and Henry II's right-hand man. Bracton was a member of the King's Court. In my last talk, I mentioned that in 2019, foreign exchange and electronic payment systems turn over the GDP of the world of about $77 trillion every 14 days. Many of the greatest financial centers in the world, such as New York, London, Toronto, Hong Kong, Singapore, Mumbai, and Sydney, are common law jurisdictions. New York and English law are the jurisdictions of choice for the lion's share of international commercial contracts. In acknowledgement of its importance to commerce, English law has been chosen for the UAE financial zones. The rest of the UAE has a civil law system. Hong Kong is a particularly interesting example, as the law of China is generally speaking based on German Roman law, as mentioned above. In my next talk, I'll explain that right from the beginning, the Stoics in the 3rd century BC and Cicero around 50 BC, but significantly not the Greeks, always believed that prosperity was fundamental for civilization. They saw that you could not create wealth without what we now call commercial law protecting property rights. Nobody would invest any money without the rule of law. The profit the Spanish and Portuguese made from the New World was immense. Nevertheless, the common law has created infinitely more wealth than all the gold the Spanish and the Portuguese extracted from the Americas. This is only one of the enormous contributions of the common law to civilization. It is no use having a legal code unless it is binding. Jurisprudence tries to explain why. One of the consequences of common law, generally speaking, being based on Roman law concepts, as are all 320 jurisdictions in the world, is that a number of jurisprudential theories as to why law is binding are surely open to question. Law, like history, must be based on evidence. Roman law was flourishing and binding hundreds of years before the birth of Christ. Around 50 BC, Cicero stated that Roman law was binding because people would not obey any moral law. For law to be moral, it must be based on natural law, which is a body of norms or principles inherent in all of us. This is correct, and much of jurisprudence would appear to be a fuss about nothing. Although it will not happen, it would surely be far more useful if Roman law, not jurisprudence, was taught in English in the third year at university. All that would be required would be to take notes on the very readable An Introduction to Roman Law by Barry Nicholas. The beauty of Roman law is that you can see how a whole legal system interreacts, as opposed to studying individual subjects such as contract, tort, etc. As Frederick Maitland said, but for the Digest, Roman law could never have reconquered the world. Justinian's Digest is one of the great works of civilization. In my view, it is the eighth and greatest wonder of the ancient world. Common law had to cover up its Roman law origins. However, we'd be much better lawyers. We had known that the common law, apart from land law, was generally speaking based on Roman law. As I'll explain in my next talk, the common law has been of inestimable economic value to the country and its former colonies, because of its ability to change quickly, without waiting for parliamentary time. Those medieval judges who held court in Westminster Hall were alive today. They will surely be astonished about the huge, unforeseen success of the common law which they had created. Over to you, Philip.
Okay, thank you very much, John. I must say, I thought it was very erudite talk, enormous amount of scholarship, but also made simple for people like me to understand. So thank you very much. And I find your argument about the enormous influence which Roman law had upon the common law to be really convincing. You know, there are only three solutions to each legal problem. And the important thing is to know what the three are. And often they will have, legal systems will arrive at one of those three. So they look very close anyway. It's quite difficult to disentangle them. But I find what you've said really cogent. You know, there are other parallels between English law and its history and Roman law. In the first place, they were both secular systems of law. They didn't have to fight with the religious authorities until later. You know, the investiture conflict in the 11th and 12th centuries between the Pope and the Holy Roman Empire were an example, which is actually won by the popes at the time. But basically, English law was a national system of law. And in some ways, I think it was a sort of a reaction to the interference of the canon law, you know, the priests. So it was a battle between the priests and secular kings. Secular kings obviously wanted to have as much power as they could over their subjects. And so being master of the legal system was really important to them. And that remains the case. The second thing, which was similar, was that Roman law was essentially practitioners' law. It wasn't professorial law. I mean, of course, one reason for that is they didn't have any universities in those days. They just had schools of philosophic thought. But you know, for instance, German law is often referred to as professors' law because of the enormous importance and influence which the universities had in the development of German law and French law as well, whereas English law is led by the practitioners. And I think that gives a different coloring to the overall feel because of the wish of practitioners to move with commerce. In other words, they knew what the deals were and they wanted the law to sort of fit in with the deals which they were doing. I think that difference still prevails between the two approaches. And there's another thing which is often forgotten, is that the Romans didn't just sell a legal system. I know they also sold a religion towards the end of it, but they also sold a language, Latin. And that language was kept alive until the 15th, 16th centuries, at least, as the common parlance of intellectuals in Europe. And in a similar way, but by a completely different route, by being invaded by a lot of colonialists from the continent, English law also, two lots of colonials from the continent, also built together a bit of a mongrel language out of those two strands, which is quite crucial to the cohesion of English law. So at least, although it may be a second language for a lot of people, it does mean that all these people can talk to each other, which I think is quite useful. Now, just a couple of sort of big perspective points, which I thought, if you don't mind, I'll sort of draw back a bit to set a bigger picture about what we're trying to do with our legal systems. The first is, understanding the history, I think is quite important. And a good way to understand it, the concept of time, is not by, holding your arms out and saying, oh, well, this is recorded time and we're just, the fingernail at the end. If you measure time by the lives, 70-year-old laid end to end, then 7 lives is about 500 years. So if you took seven lives from now, from say Picasso or something like that, and you identified Haydn and Isaac Newton's son, over a period of 7 lives, you would get back to the period of Shakespeare, Leonardo, Christopher Columbus, Galileo, just in 7 lives. And then another 14 lives will take you back to Justinian. So it's only 21 lives laid end to end back to Justinian. So what that means is that the ancients are right on top of us. They're really close because you can sort of lay them out in a very short little table. You can make a table out of, artists or philosophers and put them together in that line and tell you the whole of history. And if you go through 28 lives, you're back to the time of Christ. And if you go back 56 lives to 4000 to 2000 BC, you have really the whole of recorded history. The whole of recorded history is about 4,000 years. It's an amazing fact, for instance, that at the same time as the reception of Roman law, the number of songs which we now have, only about 8 complete songs. And the reason for that was that nobody could write them down until the arrival of Guido Lorenzo, who invented a system of musical notation. So like writing, the whole of history depends upon things being recorded. So lots of the older history, particularly beyond 2000 BC, is pretty well lost to us, except for speculations from archaeological. So that's the first thing I'm trying to say, that the past is really close to us. And over those 4,000 years, a lot of things have gone wrong, which we know, but a lot of things went right. And the things which human beings have achieved are really absolutely amazing in that tiny sliver of time. Now, the second thing, and I know this is sort of platitude, we are very, I wouldn't say ephemeral, but we're quite tiny, on our little wisp, this little solar system, and a wisp of a very minor galaxy, the Milky Way. It's very small. So we're just a sort of a single flash of a dot of a fluctuation in the void. So we're nothing really, as far as we can see. And Hubble tells us that everyone else who we might want to, get together with is accelerating away from us at some enormous pace, which is increasing all the time. So that's, the mixture of the shortness, the ephemerality of our time and what we've done with it so far, and also our position, gives me pause for thought. And what it leads me to the conclusion that we need to survive. And the reason why we need to survive, which I regard as a duty more than a need, but I think anyway most people do, because I think it's called the instinct of self-preservation, which is quite major from evolutionary point of view. reason why we need to survive is to find out what's happening. And why do we want to find out what's happening? Because we want to stay alive. And I think most people feel that. They feel very upset if they felt their grandchildren were going to face a doom. And so the question is, how do you survive? Well, you have a code of conduct, which we call our laws. They're not the only code of conduct, but they're the biggest, by far the most exhaustive and comprehensive norm, code, and it's, on the whole, for all its faults, on the whole, it's a just code, or we're working towards making it just as best we can. And if we didn't have that, then nowadays, in these vast modern urban societies, we wouldn't be able to run a society without these codes, without these laws. I mean, the most basic level, how would you run a democracy unless you had rules about the voting? How would you collect tax? Because a lot of people, wouldn't, like me, I wouldn't want to pay the amount of tax which I do. And I probably would need a lot of persuading to pay tax if I didn't have to. But I mean, I do have to. And okay, it's a charity on the whole. It's mandatory, but we all abide by it. But you couldn't have a modern state without that. And similarly, I don't think you could have a modern state without police, without courts. You couldn't have inheritance rules without having laws about inheritance, because there'll always be somebody who says, oh, I deserve it all, I'm poor or whatever. And you would never get debts paid, would you? Because people say, look, I'm really having problems here. I don't really have a home and so on. And anyway, I want to buy myself a new television set or something. So people wouldn't pay debts, basically. And that's not because they're wicked or evil. It's because that would be a fact. But also, I think that if you have a law, if you have a society without its laws, like failed states, it is pretty chaotic. You have gangs rampaging. So I think the old days when everybody was in villages with the village elders, where you relied on mutual forbearance, negotiation, and people's sort of reciprocity and all, they don't exist in our big anonymous societies now. So I think over the past century or so, our laws have become absolutely central to our societies. And unless we had the peace conveyed by our laws, which is the root of our laws, we wouldn't be able to engage in inventions, enterprise, we wouldn't be able to have homes or contracts, or anything of that sort. So everything depends upon stopping the fighting. And the main role of the law is to stop the feuds, the vendettas, the revenge, the insults, people arguing about things and there are no rules. And so they take their own course by just lashing out. And I've illustrated that before you too, and I don't mind, I've told the stories many times about the raft of the Medusa, where after the wreckage of the Medusa off the coast, 90 kilometers off the coast of Africa in 1816, 147 people got on the raft and 15 got off. And nearly all the rest were killed in the fighting for the brandy and the biscuits. And the captain had left the ship. So they had no laws, they just had anarchy. Whereas you compare the Chilean mine disaster in 2010, where these 33 miners were stuck down there, I forget, quite a long time, 6 weeks or something like that. First thing they did was to elect a leader, who was just happened to be the oldest bloke there. They elected him, and he made rules about sharing the food. And then they sat there and played dominoes, and they all get out. Why? What was one of the reasons they all got out? Because they had a legal system, they had a constitutional law, and the person in charge made rules. So I know, that's just a symbol, but that represents what I mean about survival and stopping the fighting through laws, having courts to deal with disputes and similar institutions. So I said I convert this into a duty to survive. And actually, I thought I was the first person to say that, but I was watching a program by Brian Cox, you know, the cosmologist, at the end of which, after surveying the universe, as I've just done, though much better than me, he said, you know, we have a duty to survive. I must say, I leapt up and I shouted at the television. I said, Brian, that's my line, you know. But then since then, I've discovered actually a lot of people have said that. Carl Sagan said that, and I'm sure lots of people as well. So now if we come back to the law, because I think that's, you know, that's not the meaning of life. The meaning of life is a different concept. But if you say, what's our fundamental purpose? To me, our fundamental purpose is that because we're a sort of miracle for all our faults, is to try and keep the show on the road if we can. So if you look at who created these codes of conduct, of course it was Hammurabi first, but you know that was a sort of quite a small episode. But the biggest creators of law so far have been first the Romans, no question. And they developed something which was magisterial in the sense that it hadn't been thought of before like that. And okay, it took them 1,500 years, at least 2,000, to do that, because that's how long it takes to create a legal system. And that's why nowadays, virtually all the legal systems in the world are drawn from three basic groups, families of law. One's the common law, which is the English and Americans. The second is the Napoleonic, based on France and developed also by Spain. And the third is the Germanic, what I call the Roman Germanic. And those three families of law and the mixed versions like Japan and China and Panama, Louisiana, quite a lot of them, South Africa, for instance. 90%, actually it's 89.2 in my calculation, 90% of the world's jurisdictions are based on one of those. So that's an incredible simplification of understanding the law. And also it made sense because especially now, you know, when the USSR broke up, they didn't start inventing the law again. They said, who's got the latest code? It's like saying, who's got the latest car? And the latest code, civil code at the time, was actually the Dutch code. So that's what was imported by Russia and hence by many of the other states like Georgia and so on. And so that idea of borrowing somebody else's legal system is rooted. And the biggest exporters of law at the moment are the Americans, mainly via their commercial law, Uniform Commercial Code, and insolvency law. So the big export. And even then, I think it takes at least 50 years to build a Roman system which we think suits the people. I know they do make changes, but I mean, like Swiss law, for instance, that was just copied word for word by Kemal Atatürk and his lawyers back in the 20s. So I think that is a remarkable achievement of these people. I don't think there's anything especially clever about them. It just sort of happened by a kind of accident. I don't know what it was about the Mediterranean light or something, or they had harbors, or, you know, there were all sort of people who try and explain it, why that we had that. And obviously also that European leadership in law could change very quickly. They could easily lose it to someone else. As I say, everything's very ephemeral and things happen much more quickly because time is so very short. Now, I just want to point to a few differences between Roman law and what we've got now. First of all, we've had 1830 between us, 1830, where the population of the world first struck 1 billion, and then it accelerated very rapidly, another billion by 1930, and then very rapidly. And so we now, last November, world population just went over 8 billion, and it's prophesied to go to 9.5, 10, something like that, and then to start dropping very sharply, so that if you work out the rate at which human population declines, that is half, according to one forecast, half every 50 years, then after 1,000 years, which is a quarter of our sort of historical time, after 1,000 years, there would only be 7,642 people left, or something like that. So I'm sure that's not what's going to happen. But, you know, of course, a lot of people would probably glory in that, saying we've made such a record, you know, mess of the world, that it serves them right. But that's not my view. Honestly, that's definitely not my view. Anyway, to come back to Rome, the difference from us is that the growth of population has had a fantastic effect upon our legal system because it's had a huge political effect, for one thing. I think the growth of democracy, the idea of having what the Romans had, which was a one-man show, they just had an emperor in charge, and they had no proper system of getting the right guy in charge. So you've got people like Caligula, Nero, Commodus, Domitian. I mean, they were just teenage thugs, those guys. They really were murderous types because they had no effective way of picking something. I mean, maybe you could say we don't have a very effective way at the moment, but it's better than what they had. I mean, Nero used to walk around in the streets, you know, at night with a dagger, just sort of killing people. That was something he quite enjoyed doing. So, so I think democracy is a birth of demography, really. The second thing is that they had a law of nature, as John said. They said they had a jus gentium, you know, the law of the people, where they thought it was a natural law. But their ideas of natural law, actually, we have developed a system of what we call human rights, but I call it the rule of law, which is incredibly more detailed, because it had to be, to deal with all conflicts in the overcrowded world we've got. Then the third difference is that the Romans, although they had this enormous empire, they didn't really have a proper financial system. You know, they didn't have any central banks. And they had money, but they didn't have paper money. They just had coins, which they were constantly, you know, reducing the value of, especially under Domitian. So they didn't have banks really, as we understand it. Whereas most of our money now is in banks. And why do we have money? Well, we have the means exchange, so you don't have to offer some knitting you did last night in order to buy something. And also because money connects us to other people so that we can trade with them. And the third thing is money connects us to our future, because it's a store of value we can save it up. So the functions of money were a fantastic invention. I know we have to go back to the Lydians maybe for that. But now money in our societies, particularly with the huge growth in GDP, massive growth since the time of the Romans in per capita GDP, and of course also because there are more people. You can't put it under the mattress, so you have to have banks. They didn't have them. They didn't really have banks. So, but we do. So when you switch on the light comes on. Why does it come on? Because, you know, there's a renewables power station somewhere. And who's built that? Well, it's bank money, but whose money is it? It's our money. It comes from us. It's the people's money. And the banks are just supposed to be intermediaries. Some people are not very good, but, you know, they do the best. And so when you switch the light on, it's the people switching on the light. And also, we invented around 1830, I know people say there were before, we invented the corporation. And that was I mean, it's a mark in a book, you know, it's a nothing. It's a figment of the legal imagination. But we could not have had the growth which human societies have had without that idea. It was as clever as inventing money, because they could collect the money of the people, which either through banks who made loans to these corporations, so that the people's money could be used to develop, to bring enterprise and to bring food and hospitals and all the rest of the people. And that depended on the corporation, because there's no way that the ordinary individual could manage these corporations as a form of delegated management, which also meant that if the individual became bankrupt, that wasn't the end of the corporation. And if the corporation became bankrupt, that didn't bankrupt the individual. So it was a really clever idea to work that out. I mean, a genius, you couldn't think that's out somehow unless you were there in the market to say, you know, this is what the liability should be. And so I think, of course, the Romans had a societas, it was a kind of partnership, basically. So I think that was something which is new. Now, the other thing which I must say, I'm a bit uncertain about what I think of all of it, is the regulatory system. The regulatory system now is much, much bigger than the law. The only thing which is bigger than regulation is tax. Tax, of course, is vast, sort of out of control. You need a flamethrower for these things. But regulatory systems are now the leviathans, the behemoths of our legal systems. And there are hundreds of, I mean, people say, oh, it's just financial regulation or building regulation or cars or something like that. But if you examine the whole field of regulation, it is vast, practically everything. I did a count recently. I thought we had, I don't know, there were something like 1,000 trades and professions from, barbers to doctors and lawyers, of course, but just about everybody is regulated in their profession, like cab drivers and so on. And it is vast, but the only main thing about regulation is that it only applies to a regulated sector. And so it's not general law, which is why people sort of don't worry too much about it, but it is pretty enormous. You say, could we do without it? Absolutely not. We absolutely need them, like other law. There is a question of size there. Now, I think that the Romans, probably their greatest achievement was the law of contracts. I was trying to work out how many contracts are made every day. People just going into a shop and buying a loaf of bread. So I would have thought with 8 billion people, we must be making 3, 4 billion, I really no idea, of contracts a day. And so every time a contract is made, or a lot of short-term contracts, the mighty law of contract swings in. And that law of contract, with all of its abstraction, it was very abstract when the Romans first worked it out. They worked out separate contracts for hire, for sale, and so on. And it was very detailed. And that applies to all of the massive number of contracts. Everything now from launching satellites, to buying some eggs in the morning. And their biggest contribution in the law was not taught. I mean, their taught was basically a kind of organized way of dealing with vengeance, which still hangs on in some of the plaintiff bar actions for punitive damages in the United States. The idea that a wrong is accompanied by a punitive element, which is very much the Roman, it's quite a primitive idea. It's a sort of form of punishment. So I think on something like contract, they were very precocious. They were precocious also on beginning to develop conflict of laws, beginning to develop how you deal with intangible property, which often confused people at the time, because they just thought, well, it's a nothing, this property, debts. What are they? You can't see them, you can't feel them, you can't touch them. So first of all, people wrap them up in bills of exchange and things like that. And later in share stocks. Now the wrapping is off and you just see a nothing. It's invisible. That's what Aristotle said. The whole thing's invisible. It's intangible. But of course, that's not the case, because that's the only form of property which requires two people to make it. You have to have a debtor, a creditor, a shareholder, and a company, and so on. And the fascination of the job, who, like my firm, who work in the area mainly of intangibles, is that you're not dealing with the asset. You're dealing with the two people at either end of the asset who circle each other with a mixture of, fear, suspicion, and also, mutual advantage. So they began to understand that. I must say that their initial steps were quite fumbling and quite halting in a way. But I think they made much more progress than were made for the next 1,000 years in all parts of the world on how you market and transfer these debts. Now, if you say, what are the differences now? How the law around the world has been affected by Rome? Has it just been, the common law versus civil law? That's not the case. I'm not going into this in detail, but I wrote a book last year, which came out last year, which worked out in business law what the differences were and tried to document it by specific tests. Now, Roman law and present law are still left with two major problems. which we have not solved yet, but it's, you know, it's going to take time, but will need to be solved, and it probably change all the time as well. We always have to work out where the border is about what we are ordered to do and what is private to us, what is our privacy. So on the whole, the balance at the moment is that petty rages, angers, little cruelties and so on are outside the law, and evil thoughts are usually outside the law, because otherwise, you know, an awful lot, they'd have to build a lot more jails. I think that's the practical reason. And also because one of the functions of the law is to restrict us, but only to liberate us. The purpose is to restrict us, to allow as much freedom as possible. In my view, I know that's a contentious view for many people. The second thing the law can't deal with, because it's so ingrained with us, is the group instinct. You know, chauvinism, jingoism, patriotism, love of your country, the honor of your country, the honor of your people. That is very deeply inbred in us, because that's how evolution, we worked as a sort of a team, you know, this group, because they did cooperate, because they belonged to the same clan, the same family, so they sat together. And of course, you know, that's regarded as admirable. And certainly the law couldn't forbid patriotism. But that's the great rift in modern civilization. These intense patriotisms can also be dangerous. Well, my friends, I just have a couple of words by way of conclusion, if that's all right. I think that the Romans, as I said, were very precocious. They invented, they got the work of the law going, and they understood that the purpose of the law was peace. That's what they understood, that at bottom, and on the whole, they kept a kind of a peace within their empire. Now, I've just written my memoirs, and in those memoirs, which are written not for my contemporaries at all, they're written for the future, my grandchildren, the grandchildren of only for them, because I think they need to know, you know, who we were, because I wish I had known what my grandparents thought. We never talked to them, you know, part of a lot of things were taboo, they didn't talk about. So I think, and when I was writing this, I did think I spent an awful lot of time in my law. About 60 years of my whole life has been preoccupied with this subject, you know. That's why I can write such long books, because I spent a lot of time writing. And when I was very young, on fishing with my dad on the Zambezi River under the hot sun, just a couple of miles up from the Victoria Falls. I used to go out fishing sometimes when I was only 9 or 10. If I had thought then, because my dad was a lawyer, if I had thought then, seeing what sort of life he led, I think I'd have just, if I thought I was going to be a lawyer, I think I'd have thrown myself to the crocodiles there and then. But now, you know, I'm glad I was a lawyer. And I hope you are too. Thank you very much. Oh, John, I have to go off to a meeting up in London. It takes me a long time to get there. So would you mind very much taking the questions? I'll certainly participate in answering some of them afterwards. I thought they were very, very good questions which people have put up already. And I think they all deserve a careful answer. And so I'd like to help with that. But I'm Fred, would you mind taking over from now on?
It's fine. Yeah.
Thank you very much.
Thank you both so much, and thank you, Philip. I know you need to head off. So we have received quite a few questions before today and through the Q&A. So we probably won't get to all of them today, but I promise we will get John and Philip to look at any questions that we don't cover. Thank you, Philip. That we don't cover, and we will share those with you when we circulate the recording, because I know we're a bit pressed for time now. So let's get to a couple of them, and then we can catch up on the rest. So the first question that came through was, does the produced common law then substitute the practice of Roman law elsewhere, or its development driven by areas operating with English language? John, can you hear me?
Yeah, yeah, fine. Whilst generally being based on Roman law, the common law rules must substitute the practice of Roman law, because Roman law is not a source of law in common law systems. Taking what was written in Glanville in 1189 and Bracton in the 1220s, the judges developed those principles in cases decided in Westminster Hall next to the House of Commons, and later in other English courts. After our colonies became independent, their common law courts developed the principles in English cases, so that a body of case law developed in the newly independent countries. The common law is the law in most of Britain's former colonies. However, note that on the one hand, not all British political entities have a common law system, even though they speak English, e.g. Scotland, Channel Islands, Isle of Man, South Africa, Quebec, Louisiana. On the other hand, note that some political entities have a common law system, even though they speak other languages apart from English, e.g. Hong Kong, Singapore, Malta, and the UAE financial zones.
Thank you. Next question, how can I make these topics bite-sized for work experience students?
In my opinion, everybody should read Barry Nicholas's An Introduction to Roman Law, or listen to Philip's and my webinars as part of their work experience. Standards are rightly high for those wishing to practice Allen and Avery, as they are at ANO's competitor firms. Learning Roman law would make us all much better lawyers.
Next question's a bit of a long one. I always wonder how we perceive reality of now or the past, and whether one can incorporate a gender lens to it, however challenging it might be. Would women through time have praised the systems, and how would their input, if sought, have impacted life today? How much further ahead would we be? How has feminist thinking been accepted? Perhaps you could add a guest speaker if not your forte. We tend to have colonial and patriarchal pride overflow on these topics, and how can we evolve emotionally from what winds up coming across as supremacist a lot of the time? Did Ireland have laws, for example? Quite a lot to unpick there.
Yeah, perhaps surprisingly, there were quite a number of very influential women in the Roman Empire. For me, the most interesting is Galla Placidia, the daughter of the Roman Emperor Theodosius I. Her brother-in-law Honorius I arranged for her to be married to Atalf, king of the Visigoths, from 1414 until his death in 1415, after his brother-in-law had sacked Rome in 410. Galla Placidia was then briefly empress consort to Constantius III in 1421 and managed the government administration as a regent during the early reign of her son Valentinian III until her death. This is quite a career. Other powerful women in the Roman Empire include Livia, wife of Augustus. Agrippina reputedly poisoned Claudius so her son Nero could become emperor, who murdered her because he said she was too powerful. Cleopatra, ruler of Egypt. Julia Domna, wife of Emperor Septimius Severus. Theodora, wife of Justinian, etc. Mary Beard's Emperor of Rome has 2 chapters on women in Roman society. Jane Gardner, in her book, looks at the position of women in Roman law. In my last talk, I expressed my view that the Roman Empire imploded due to the egos of male rulers getting out of control. Of course, in the ancient world, there was no equality, and there should have been. At all times, we would have benefited from wiser counsel at the top of politics. Nevertheless, just as George Bush and Tony Blair's egos got out of control in invading Afghanistan and Iraq, so I'm afraid to say did Margaret Thatcher's and Liz Truss's. So even if there had been equality, the Roman Empire may still have fallen.
Thank you. Next question. If they don't already plan to cover this topic, it would be great if John and Philip could compare how English common law and French custom evolved side by side for a few centuries, and why common law resisted whilst the French coutume disappeared or was replaced by the Napoleonic Code.
As I understand it, after the French Revolution, law was pretty chaotic in France, and each party to a case arguing that either custom law or Roman law, as set out in Justinian's Digest, should apply, depending on what was in their interests. Napoleon put a stop to all this when in 1804 he enacted his code. Although based on Roman law, the code also took into account custom. This was considered better. What was set out in code could not be challenged by what was considered to be the law earlier, e.g. after 1804 in France, you cannot refer to Justinian's Digest. Note Scotland and South Africa do not have codes. So in theory, you can refer to Justinian's Digest today.
Thank you, John. I think we've got time for one more, and then, as I said, we will address any remaining questions that we haven't got to, and I'll circulate the answers from John and Philip. But the last question is the common law system really so different from the Roman law, considering the importance of the jurisprudence in the latter?
Jurisprudence really answers the question why law is binding. There are many theories as to why law is binding. Personally, I think Cicero gave the answer in around 50 BC, when he said, to be binding, law must be moral. His view of what was moral law was that it must comply with natural law, which is a body of norms or principles inherent in all of us. If so, I do not think common law or civil law jurisprudence is different. Many people, however, would disagree with me.
Thank you, John. Thank you so much to John and to Philip for this talk today. It's been really well attended, and we've had so many questions and queries through that we will address. So thank you everyone who's joined the session and to those who submitted questions, and we hope that you did enjoy this talk. We're keen to receive your feedback, as we always are. So in a second, you should see a QR code on your screen that will direct you to a very short survey on our event. So if you open the camera function on your mobile phone, you can scan the code, a pop-up link will appear, and that will redirect you to the survey. It will only take a moment for you to complete, and that will really help us to make sure that we're improving our future events. So thank you again, everyone, for joining us today, and we hope you enjoy the rest of your day. Thank you.